This is Greg Lois. Good afternoon. I hope you're having a wonderful day and it's warm and comfortable wherever you are. We just had a unseasonably warm Saturday here, and now it's back to freezing temps. By Sunday, it was back to 20 degrees, and now we're at 30 again. So it's back to cold weather. It felt like spring for just a few minutes there. And now we are back to freezing cold. Good afternoon, welcome. Today we are going to be talking about New Jersey cases, and we're going to talk about how we use motion practice to stay in control of our Jersey case. And that's what our topic is today. Disclaimer, this is for instructional purposes only. It's not legal advice as to any particular matter. In today's handouts, you should have a copy of the chapter from my book that we're going to be taking a cue from today, so that should be in your handouts. This is a completely live webinar, so please take advantage. If you're here spending your time with me today, please ask questions. There is a question bar that you can type into if you're attending this webinar live. And I will do my best to answer as many questions as possible at the end of this webinar. But my goal today is to talk about New Jersey motion practice and how we use motion practice to stay in control of our Jersey case. Remember, in New Jersey, you have this amazing advantage, which is you can control and direct medical care, which means you have an opportunity to stay in control of this case and not lose it. So we are going to talk today about general motions, how we use them to make sure that we are getting the discovery we need, how we're moving our case forward. And I'm also going to talk about how we defend against losing control in our case. And the way we lose control in our cases in New Jersey is, of course, when the petitioner files a motion for medical and temporary disability benefits and asks the court that the petitioner be put in charge of their own care. Well, when that happens, you're going to lose control of your case, and I'm here to help talk about how we avoid that. How do we defend those motions? So buckle up. We're going to have some fun today talking about this topic. And again, my goal is to make this as useful and practical as possible, and also to give you some tips and tricks that you can use in your practice. Now, everything we're going to talk about today comes from the rules of court or the statute. So a lot of the basis or the premise for us being able to use motion practice and how we advance cases. If you don't have a copy of the rules of court, you can download it from the court's website. And some of the motions or some of the rules that we're going to talk about today also come from the statute. So familiarity with the statute. And the way we apply this is we always think about, okay, we have these rules, we have these statutory requirements that the petitioner has to follow. How do we utilize this so that we are either A, creating leverage or forcing opposing counsel to provide us with information so that we are ready for trial? So those discovery and disclosure motions that we're going to file, we're going to talk about. Now, today we're going to talk a little bit about procedural motions, and we're going to talk about petitioner when they file a motion for benefit. That's their attempt to take control of the case. So today, you'll hear me talking about the most common procedural motions we follow. And again, how do we defend against motions for med in temp effectively? Our approach is always a rules-based approach. And when we are working with you as your counsel, and I think this is a best practice, we're always thinking about how do we apply this? How do we either create leverage in the case or stay in control of the case? Now, a little bit of foundational knowledge about how motion procedure works in this jurisdiction is just super useful for us in showing you how we do what we need to do. And there are specific rules that both opposing counsel and defense counsel have to follow. So those rules all come from the Administrative Code provision, section 3.5. And again, this is long court lingo. I don't expect you to read it. So let me translate what this means to you. What it means is all motions other than a motion for med in temp shall be in the form of a notice of motion, which means the parties have to issue both a notice of motion, a certification of counsel, and a proposed form of order. And I could tell you, more frequently than not nowadays, I am seeing defective motions filed in this jurisdiction. where opposing counsel is literally just going on to Courts Online, that's the court online docketing system, completing a notice of motion electronically and using that as the basis for their motion relief. Well, that is defective on its face. And so knowing a little bit about how the court rule works and how a motion is to be actually supported is important in defending against these motions. The second rule I'm going to draw your attention to is section 3.5b, which says a notice of motion or a motion is considered uncontested unless a responsive paper are filed with the court within 14 days of the service of motion. So in other words, when we file a motion seeking relief or asking the judge to compel the petitioner produce something, they have to either provide us with the thing that we're requesting or grant us the relief requested, or they have to file a written opposition. And again, that court rule says that written opposition has to be filed within 14 days. Well, often that is not done. The one exception to this 14-day rule is a motion to dismiss for lack of prosecution. The court rule specifically says that if you're going to get a dismissal, there is a different timeline, and that timeline is there has to be a hearing, and that cannot be scheduled and heard unless 30 days has actually elapsed. So that's important for you to know. So some practical tips just in noting this about motions is when you're filing a motion, our practice here is to follow up and within 14 days. And if the opposing party, the petitioner, has not opposed the motion in writing, we send a letter to the court and say, hey, 14 days has now elapsed, Your Honor. As you know, the statute says if they have not opposed it in 14 days, you shall grant it. And that is a shall, not a may, shall. The rule says shall grant. So that's useful for us, particularly these basic procedural motions or discovery motions, where we're simply asking that the judge compel the petitioner to either produce information that they're required to under the statute or rule, or to comply with a prior order of court. So that 14-day rule is very important. Every motion can be decided that way with the exception of motions to dismiss. Motions to dismiss, and I'm here on bullet point 3, require 30 days and a hearing. And any other motion, though, does not require a hearing, so you should make an argument that, Judge, you should just decide on the paper to grant my motion. We also sometimes have to remind the court that when the petitioner's attorney shows up in court with a bunch of excuses as to why they haven't complied with our motion, that's not the same as filing opposition. It means it does not meet the letter of the statute. And it's up to us, your defense counsel or any defense counsel, to educate the court, remind the court as to the court's responsibility, which again, the statute says they shall grant the motion unless there is written opposition received in paper within 14 days of the filing of the motion. Again, most motions then should be granted on the papers and without a hearing, and certainly without opposition filed by opposing parties. So that's really something for us to harp on and push. I could also tell you that we're very aggressive about this when we raise this issue in court. We say, Judge, there simply hasn't been an opposition filed. You should just grant our motion. That really gets the other side activated and engaged in the case. And again, that's just an opportunity to resolve or settle your matter. So again, knowing these rules and how they apply and forcing all the parties to follow them, that's part of what we're supposed to be doing. Now, sometimes motions are strategy. Most of the motions we file are tactical, but some of them are strategic. So using a motion to assert a jurisdictional defense. What's a jurisdictional defense? Well, a jurisdictional defense could be something as simple as not the right employer, right? If we're not the correct employer in this case, they've got the parties wrong, well, the court has no jurisdiction over us. So those are jurisdictional motions, right? Another one, example of a jurisdictional motion would be an argument that the petitioner has failed to file their claim petition within the time allowed by the statute, which generally is within 2 years of the date of loss or last payment of compensation. And remember, paying for medical treatment or paying for lost time benefits, that's a payment of compensation. So when you're filing those motions to assert a jurisdictional proof, you really want to be following up on those because those are strategic motions. If you prevail, their case might come to a conclusion or be closed. Another example of a strategic use of motion is precluding or limiting proofs. An example of that is I'm going to move to preclude the petitioner's expert report because maybe information was provided to their expert which was not provided to us under the petitioner's discovery obligations. Oftentimes we will file a motion and the way the case will be resolved will be by way of a quick lump sum settlement or dismissal pursuant to Section 20. So again, I'll consider that a strategic use of motion. I am filing the motion, maybe not because I intend on actually prevailing on the motion and then maybe exposing my client to having to defend that motion on or that order on appeal, but maybe I'm just using the motion or that for the purpose of getting the other side to be amenable to a Section 20 dismissal. So think about using motion strategically in this jurisdiction. Courts, the court system has a computer system that they allow us access to as parties. It's called Courts Online. So when you hear New Jersey attorneys referring to the Courts Online filing, we're really talking about the electronic docketing system that all the parties are entitled to have access to. And I would tell you that as either defense counsel or as a risk professional, you need to understand how the Courts Online docketing system works, how to search for, and how to file pleadings and motions electronically. Now, if you are listening to this and you are a carrier or a third-party administrator or even a self-insured, you should have access to the Courts Online docketing system. It will help you to follow along or keep tabs on the progress of a case as it moves forward. So you should have access to them. Again, we've already discussed how each motion needs to have 3 parts: a notice of a motion, a second part setting forth the factual or legal basis, usually supported by affidavits or certifications made by the attorney, and a proposed form of order. And each motion has to have each one of these 3 parts. If they do not have a single part, they are a defective motion. And we can make an argument to the court clerk, not even the judge, to the clerk, hey, this motion shouldn't even be listed for a hearing. So knowing mechanically what parts of a motion need to be filed or prepared by the petitioner helps us defend these motions. All right, let's jump into our procedural motions. First motion you might have seen is a motion to default you. The petitioner can file a motion to default us if we fail to file an answer to the claim petition within 30 days. In general, this is a rarely granted motion. A motion to default are routinely filed where maybe the carrier or the third-party administrator or the self-insured employer haven't referred the case to defense counsel quickly. We haven't filed that formal answer yet. You will see a motion to default. In general, when you see those motions, that's really a petitioner not seeking to default you, but really trying to get your attention so that you actually file your opposition pleadings. So just be mindful of those. In my experience, and I've been doing this for 23 years, my first job in 2001 when I was admitted to the bar in the state of New Jersey, actually 24 years, wow. Was in all that time, in all that 24 years, I think I've ever seen a motion to default be granted. That's generally because the courts will be generous and a little bit liberal and allowing us extra time to answer. So if you feel like you're being defaulted or you get that notice to default, just understand that can be cured, that can be fixed. It's very rare for you to actually get defaulted. The next motion that's a procedural motion is to change the venue. The petitioner is generally the party that's trying to change venue. In the past, this was often done so that petitioner's counsel had an easier commute to court. They would try to move cases into their home courts. This is rarely granted, and it should never be granted simply for the convenience of counsel. In light of the modern semi-virtual practice in New Jersey, this motion is becoming more rare. Another motion that we see is a motion to consolidate. Often we will file this procedural motion where you have an accidental injury case and a medical provider claim is a great example where we're going to try to consolidate all of the matters pending against a single respondent that arise from the same accident or loss into one consolidated action. And the reason we do this is really just efficiency. It's a lot simpler. and to make sure that all the parties are present. So motions to consolidate will typically be filed by us, the defense. It's also possible to do a motion to join additional parties, and that is allowed under Section 3.6 of the rules. This is, of course, subject to the court's permission to do so, and really there has to be a good reason. The burden of proof is on the party seeking a joinder if we're trying to add an additional party. So another example where that typically would happen is a case involving multiple potential employers, successive injuries, where really the only reason there are multiple cases pending would be because there are multiple periods of coverage. Another instance where you'll see a joinder is where there are contractors or subcontractors that need to be brought into the case. Now, when we filed the motion to join other parties, we have to follow the normal motion filing rules, noting that we have to serve the parties effectively. There will also be motions to join medical providers into the workers' compensation accidental injury case, and those are done to make sure that we, again, are resolving all the issues arising out of a single accident under one docket number and simply. And again, this is really done for efficiency reason. There's a special motion that the petitioner can file, which is called a motion to preserve the petitioner's credit, which can be filed in medical provider claims. And the reason for that is to preserve or save their credit. In this jurisdiction, the respondent is always 100% responsible to pay for all necessary and curative care. That's what it says in Section 15 of the statute. Respondent must furnish, it says, all necessary and curative care. Well, that implies that the petitioner should never have to pay out of pocket for any treatment. And if they do, there's a motion that petitioner's counsel can file to preserve their credit to make sure that they do not get dunned or have a harm done to their credit history for failing to pay for that treatment. All right, let's move on to some discovery motions. Now, again, these are generally filed by way of motions to compel compliance with a required statutory or rule-based discovery demand. And by the way, in this jurisdiction, as we talked about in last month's presentation, there are a lot of opportunities for discovery and disclosure. In this jurisdiction, you can serve interrogatories, you can do all sorts of things. And so this motion opportunity is to make sure that we preserve our right to get all of the necessary information we need to defend our case. What permitted discovery is allowed is pretty extensive in this jurisdiction. Now, some discovery is allowed without motion. For example, everything that needs to be contained in a pleading, any medical record, and by the way, that extends to any unauthorized medical records that the petitioner has obtained. So they've gone out and gotten medical treatment that they didn't ask for our permission to do. Well, they have the responsibility to provide us with all of those medical records. Another example is HIPAA releases. Releases that are compliant with both the New Jersey HIPAA statute and the federal statute, those can be served on opposing counsel and should be returned to you executed and signed without the need for any motion or any court permission. And of course, everything that we've paid is also discoverable. What kind of matters do not require a motion for discovery? Well, some of the case types or claim types, we automatically get specific discovery. A good example of that is a reopener claim. Now, the formal name for a reopener claim is application for review or modification of award. And the court rules state that when the petitioner moves to reopen a previously resolved, settled, or judged case, meaning judge issued an order following a trial, the petitioner must provide us with copies of all medical records for interim care, as well as answers to interrogatories. So there's a good amount of information that we're going to be able to obtain in those cases that might not be normally discoverable. Dependency claims. We're entitled to additional information in dependency claims, which includes an affidavit of actual dependency and interrogatories. And the same holds true for occupational disease cases, in which we will be available to us will be answers to interrogatories. Now, interrogatories are an incredibly important tool in this jurisdiction. Why? Because they are the same as if the petitioner testified to the matters within those interrogatories. Some advice about interrogatories in this jurisdiction. we try to use them as often as we possibly can. Again, we can't do depositions in this jurisdiction, so interrogatories, which are lists of questions that we come up with, the petitioner must both respond to those requests and also certify those answers. So those answers, when you receive that documentation, are the same and have the same legal import as if the petitioner had testified to that at trial. So interrogatories are an incredibly useful tool in this jurisdiction. The time to answer interrogatories are important. First, the petitioner can serve interrogatories upon the respondent within 30 days of us filing an answer. Respondent can serve interrogatories within 15 days of filing the answer. And strategically, to make sure we always are issuing this where we have the opportunity to do so, we are serving interrogatories at the same time we file our answer. So again, you don't want to give up your right to these interrogatories in reopener, dependency, or occupational exposure type cases. Now, some discovery does require a motion because it is not automatic under the statute, and maybe the opposing party will not give you that discovery unless they have an order compelling. A great example of that is in medical provider claims. And by the way, I know everyone at home who's listening to this or participating, your two most frustrating case types are 1, reopeners, and 2, medical provider cases. Medical provider claims, there are no enumerated discovery devices that are automatic in a medical provider claim. And so oftentimes we will have to file a motion to compel the other side to provide us answers to some standard interrogatories we serve. So just be mindful about that. Also, I will just tell you this, in any case that you want to serve discovery where the discovery is not automatic under the statute or rules, you will have to file a motion. And remember, under this jurisdiction, there is only limited discovery under the rules. You know, workers' compensation, the whole system was intended as a diversionary system to avoid lengthy discovery and long drawn out procedures and long trials. Of course, as the practice has developed over the last 45 years, since 1979 anyway, when the statute was amended, workers' compensation cases now move at a snail's pace, and whatever goal of having quick and speedy resolution has been thwarted by the very slow progress of cases before the court. But the courts were intended to have limited discovery. Interrogatories are promulgated by the court, and so if we use those interrogatories that the court has promulgated, again, in reopener, dependency, and occupational exposure cases, you're fine and fair. But if you want to serve expanded interrogatories or expanded discovery processes, you need to file a motion. Depositions in this jurisdiction are generally disallowed, but you can do it if you can show good cause. In my experience, I've never really seen a case that had depositions in it. In general, the judges will require testimony to be taken in court, so you're not going to have an opportunity, for example, to depose a party. The one exception to the no deposition rule in New Jersey is where the claimant is infirm or likely going to die before the case can reach the trial calendar. In those instances, the court will generally permit the deposition, at least of the petitioner. So what happens now when you have served valid discovery demands on opposing counsel and they have failed to respond? So you can now move before the court to do some things. So you can say, Judge, they failed to comply with a valid discovery request. Judge, you should dismiss their case for lack of prosecution. That's one relief that we can be demanding, right? And that's typically the demand. At what I generally do when I'm moving to compel discovery, I'm saying, Judge, I'm defending this case. I'm entitled to interrogatories in this case. Opposing counsel has not provided me with executed copies of those interrogatory responses. Your Honor, you should dismiss their case for lack of prosecution. Now, generally speaking, the judge is not going to grant that motion, but they will generally issue an order compelling the petitioner to respond to that discovery demand. If the petitioner then fails to respond or comply with that order, saying you need to give Greg and his client answers to interrogatories, medical records, HIPAA releases, releases to get Social Security records, whatever it is that we're asking for, right? It could be social media passwords. If the judge orders them to do it and they fail to do it, well, then the judge is more likely, when I move to enforce that order, to dismiss the case for lack of prosecution. You should also know that if the petitioner serves discovery on us and we fail to respond, and we don't have good cause for failing to respond, the court can suppress our defenses. What are they generally going to do? They'll suppress defenses usually in the form of refusing to allow our experts either their reports into the case or allow them to testify. That's a typical method of suppressing our defense. So just be mindful about that. Now, where they fail to respond to our valid discovery requests, we can, of course, move to dismiss for lack of prosecution. But as I've told you before, the judge will generally issue an order compelling them to respond to our discovery request, and then we can then try to enforce that order. Now, an important point here is if we fail to move for relief from a discovery violation, we may waive our right to the discovery requested. Let me translate that into plain English. And this is really important for us. If we serve a discovery request on opposing counsel, and they simply fail to respond, they're busy, or maybe just as a matter of hand, they refuse to respond to all discovery. That's what I generally say. They're overwhelmed, they have too many cases, they can't possibly respond to our discovery request, or they respond in a partial or incomplete way. Be warned, defense. Be warned, employer, carrier, self-insured. If you don't move to enforce that right, you may have waived your right to receive that discovery. And what that really means is when you have not enforced your discovery opportunity, later, it could be a year later, it could be 2 years later, now the case is not resolved. There are issues as to the nature and extent of permanent residual disability, and the case is going to go on to trial. And you say, well, Judge, before we go to try this case, I think you need to enforce them to respond to my interrogatories or give me these HIPAA releases. The opposing party could say, wait a second, you didn't enforce that at the time. Discovery is now closed, and therefore you cannot get a motion to compel or strip my defenses or strip my arguments now. So be very warned. Motion practice to compel specific discovery, in my estimation, that you have failed to follow up on, you might be waiving it. And this is why, and so that's very dangerous, right? I do not like ever waiving a defense or waiving an opportunity to gain additional information or insight into the opposing party's case. And one of the reasons it's so dangerous is where a client has asked me to substitute in or take over a case from prior counsel. Very first thing I do when I substitute into that case is I go through it very carefully to say, did they actually issue discovery demands? Were they responded to? And if not, I have to almost immediately move into motion practice to compel the other side. Otherwise, I'm going to be deemed, and my clients can be deemed to have waived that. So just be especially mindful about that when you substitute into a case. I already told you that you can sometimes take a deposition to preserve the testimony of the petitioner where the petitioner is expected to die. Again, extremely rare that this would ever happen. The petitioner can file a motion to commute the award or accelerate the award. Generally speaking, these will almost never be granted, but these are possible to be filed. I have seen cases where the judge would commute a small portion of an award so the petitioner could have some right now money. Maybe the petitioner wants to open a small business or they want to go back to school and they need some seed money to start that, and they already have this giant award of compensation sitting out there. The judge may award a commutation of just a portion of the award. I see it very rare that they would commute a whole award. You should also know that when an award is commuted or accelerated, so you are required as the respondent to pay out for 300 weeks, and you make a motion, or an opposing party makes a motion to commute that down and pay them all the money right now, guess what? The reopener period has not changed. It is still 2 years from the date payment would have been due, or that 300 weeks, which is 6 years from now. So you have not changed down your reopener period. So just be mindful about that when you're asking to commute. A motion to recuse a judge can be successful, particularly where you can show the judge has a bias, like their family members involved in the case, and it goes on to even define what would be a specific judge's bias or ground for recusal. Again, rarely done in this jurisdiction. Very frequent that we file a motion in this jurisdiction, a procedural motion to dismiss for lack of prosecution. Why? Well, because the petitioner has simply fallen off and we can't find them. They're missing medical appointments. They're missing IME appointments. They've done something to slow the progress of this case towards resolution. We can make an argument that the case should be dismissed for lack of prosecution. Now, just know that these cannot be granted unless 30 days have elapsed since the filing of the motion. And again, that's where the petitioner does not oppose it. Also, where the judge grants it, they can grant it with or without prejudice. With prejudice means I'm granting this motion to dismiss for lack of prosecution. You have not shown affirmatively that you are pursuing your case, petitioner. Your motion, I'm throwing your case out, right? That's a goal for us. We'd love to get cases dismissed with prejudice. However, most of the time, a dismissal for lack of prosecution will be entered without prejudice, which means the case can be brought back for good cause. And the statute defines good cause for restoration. And it says there any substantial reason that affords legal excuse for the default. Okay, so that's what the statute says. And again, that's from, that's what the case law says. So what has been found to be good cause? Oh, I was busy. I moved to a different country. I wasn't pursuing the case, but now I do want to pursue a judge. I've really seen judges sort of expand or kind of allow almost any excuse to constitute good cause. I think there are grounds for argument that, hey, simply you didn't feel like pursuing this or you felt like going on vacation instead of going to your IME, probably aren't great grounds. But again, just know that a motion to restore is possible. In my experience, where a case has been dismissed without prejudice for the petitioner's lack of prosecution, in a very high percentage of those cases, we then can resolve them by way of Section 20, a lump sum dismissal for some nuisance value just to get rid of the case. Because remember, the petitioner should cure whatever was the grounds for us moving to dismiss for lack of prosecution. So where we've moved to dismiss because they've missed 5 IME appointments in a row, right? To me, that's a very strong basis for the case to be dismissed. Well, the judge should not restore the case until they actually appear for our IME, right? Or do the obligation that they had under the statute or the rules. So again, this is a great opportunity to bring your case to a conclusion by filing these motions. Some other procedural motions include a motion to join the uninsured employers fund, and I'm not going to talk about that in any length. Just remember, in cases that involve the uninsured employers fund, it's going to involve a new party, and the case is going to slow down. Oftentimes, the Deputy Attorney General representing the uninsured employers fund is going to try to point back at any one of the viable business entities for contribution. They do not pay permanent residual disability benefits, so just remember they may be coming forward to you to try to get contribution from you. And again, there's going to be some offsets, there's some eligibility requirements, specifically to pursuing benefits under the uninsured employers fund. And again, I'm going through this rather quickly. You can read the chapter in the book about this because this is not that applicable in general practice. Again, the uninsured employer fund contribution to your case or joining your case really means you should be getting out of your case because you're not the employer or carrier. And in general, this is going to slow down the overall resolution of your matter. All right, our next motion is a motion as to sufficiency of pleadings. And this motion we do file. Generally speaking, when you see a claim petition, and we've all seen this claim petition, it makes us furious, right? Claim petition, John Smith says he got injured working for ABC Corp. Okay, what is this claim petition about? We're gonna dive in, let's find out about it. And it just says, where did injury occur? At work. Okay, what got injured? My body. What are the specific nature of your injuries? And it just says orthopedic, neurologic, psychiatric. I mean, that's not even enough information for me to really file my answer. It's so general. So where you do see claim petitions that are super general, that aren't specific at all, you can file a motion and say, Judge, either this case should be dismissed because it's so general and vague, I can't be expected to formulate a real response to it. Or Judge, you should make them go and file less evasive pleadings. And the judge will in general grant that motion. All right, let's talk about motions filed by the petitioner and applications to review or applications to review or modify a previously closed case. These are filed by the petitioner. A reopener application simply says, my condition has worsened in a material way and I require more compensation. A reopener has to be filed within 2 years of last payment of compensation. Now, a little practice pointer here. I know that these are always filed by the petitioner, never filed by the defense, but if you're ever defending a motion or a reopener case and your discovery reveals, wait a second, they might actually be better than they were at the time of the last either settlement or judgment in this case, because again, you can reopen a judge's determination and say, Judge, you were wrong. I'm actually far worse than you found me to be 8 months ago when you put this case through, or 6 months ago. And again, I've seen some offensive ones where they file a reopener 2 months after they accept a settlement, or we finished a trial and the judge has adjudged their overall condition. Their jeopardy attaches to them as well, because if we can demonstrate that their condition has improved or was never as bad as they claimed it was, or there was some concealment there potentially, we can have their award reduced. So don't forget that reopeners can work both ways, so be mindful about that. The dangerous motion is the motion for medical and temporary disability benefits. In this motion, the petitioner is claiming, I needed more medical care to cure and relieve me from the impact of my accident, and it has not been provided to me. So the statute says inappropriately restricted, prematurely terminated, or not provided at all. Okay, so this is a dangerous motion, and you should be really on edge when you see one of these. In fact, we consider these like the highest level of urgency at LOIS Law Firm when we get a motion for med intemp. Because yeah, it can involve a need for medical care, and that might be emergent, that's possible, or urgent. But what's really dangerous about a motion for med intemp are two things. One, you're about to lose medical control of your case if you don't prevail in defending that motion. In other words, the petitioner is saying, I should be in charge, not respondent, of my medical care. Well, we've discovered that when you lose control of the medical aspects of your case, you've lost control of your case, and you are now just along for the ride with a crazy driver, and you don't know where you're going to end up. And the second thing is petitioners are very motivated to file motions for med intemp because A, they get to be in charge of their own care, they get to pick their own doctors, and you don't want that. But number two, petitioner's attorney can ask for a fee on the motion. What's the basis for the fee? Well, it could be anything. Most judges don't ask the petitioner's attorney, well, how much time did you spend working on this motion? Oh, 3 hours? Oh, okay. I'm going to award you $200 an hour because that's what defense counsel is getting paid. So $600. No. What the judges do is they allow the petitioner's attorney to make an application for a fee that's up to 25% of all of the medical treatment and lost time compensation that follows them filing the motion. So in New Jersey, where there's no medical fee schedule, and a surgery, like a simple surgery, might cost between 6 and 12 times what it would cost in any other state or under any medical fee schedule, a petitioner goes and gets an operated knee, an arthroscopic meniscal repair. Well, in New Jersey, that's going to be between $60,000 and $70,000 because, again, we don't have a medical fee schedule, and physicians are allowed to charge usual and customary. Well, guess what? Petitioner's attorney is going to ask for a 25% fee on the cost of the surgery, which could be $15,000 to $20,000 in fees. And you can clearly get into situations where the petitioner's attorney in fees is going to recover much more because they filed these motions for med intemp that the petitioner is going to receive in the actual underlying case. So be especially wary of these. Predacious attorneys, petitioner's counsel, look at these as opportunities to generate fees from the workers' compensation system. So these motions for med intemp are one of the most dangerous aspects of practicing in this jurisdiction. Now, the judge is supposed to determine if the care sought is truly reasonable and necessary, and they're supposed to do this and make this determination before the petitioner goes out and gets the medical care, okay? The petitioner is not supposed to go get a whole bunch of medical treatment and then try to argue that they should have been provided under the statute, okay? They should have filed a motion for med intemp, and the court should throw out those post hoc filings. The motion itself must establish that the petitioner needs the treatment and is currently temporarily totally disabled, although no wage loss has to be compensated in order for them to be successful in the motion. They simply have to show that they require or deserve additional medical care and that we have not authorized or provided. They also have to provide basic information. And to translate this to you, they have to show us a detailed account of what lost time was needed, and they have to show us what physician is saying they need additional medical care. And it has to be specific. They have to be saying, well, this doctor said I need a surgery, and this was denied by the carrier, and that's not fair. Okay, that's what they have to argue. Asking for second opinions or asking for speculative treatment or testing, that is not a valid basis for a motion. So where the petitioner files a motion and says, well, I didn't like the doctor you guys sent me to. I want to go to this other doctor who my family likes a lot. You should send me to them. That's not a valid basis for a motion. And so, be mindful about that, because the best way to defend a motion for med intemp is to prove that the motion is defective on its face. You can say, this is moot, Judge. This motion is either asking for treatment that we've already provided, for example, or it's asking for treatment that no doctor has actually ordered. Again, you need to sometimes focus the court on the fact that second opinions are not correctly the basis for a motion for med intemp. Now, you also have an opportunity to defend with contradictory medical, because you have are allowed under the statute to go and get an IME or a defense medical examination to generate contradictory medical to argue, hey, this treatment was not necessary. It should not have been provided. So you have that opportunity as well. In my opinion, when you are defending a motion for med intemp, there is no one size fits all answer. Take your time, review what they're actually requesting, see if they've actually already requested it and actually been denied, or they've never requested this treatment in the past, because they have an obligation to ask us for the treatment before they go and file a motion for it. Also, make sure it's not moot. I cannot tell you how many times the petitioner's attorney has filed a motion for med intemp seeking specific treatment, usually invasive care like a surgery, and we dispute it and we say, no, they talked about that with the physician. They said they didn't want the surgery. The petitioner gets on the stand, and my cross-examination is, isn't it true that you discussed the potential for this surgery with your physician? Yes. Isn't it true that you declined the surgery when it was offered to you? Yes, also true. Do you want the surgery? In other words, if the judge authorized it today, look, the judge is sitting here in the courtroom, and if they authorized it today, would you obtain the surgery? Would you actually undergo it? The person goes, no, I don't really want it. What are we doing here, right? That's a moot or defective motion for med intemp, because the petitioner would not actually ever go all the way forward and get that care. So just be very thoughtful about the way you prepare and respond to the motions. Oftentimes, the only way to defend a motion for med intemp thoroughly is to get a defense medical examination. You should also know that normally we only have 21 days to file an answer to a motion for med intemp. The exception to that is if the motion for med intemp is what starts the litigation. In that case, we will have 30 days. I will also point you to a case that you might want to read in your spare time. It's called Capel versus Township of Randolph. It's a pretty amazing case in that the defense in that case did not present any written opposition to a motion for med intemp. They simply relied on New Jersey's very informal court system and court procedures to go into court. A petitioner had filed a valid motion for med intemp, and they went into court and they argued as to why they shouldn't be granted and said, look, it's defective. They had all sorts of arguments, but they didn't file anything, and they certainly never got any contradictory medical. Ultimately, that case, the trial judge found against them. It was appealed, and the appellate division really came down and smacked down the defense counsel and said, you didn't do what you were supposed to do. You didn't file opposition. You didn't follow up on opposition. You didn't file effective opposition, so you are out of time and you don't have a defense to this motion. All motions are listed quickly. These are given high priority by the court, and they can be even accelerated from the normal 3-cycle adjournment system. Everyone follows the same order of proofs. I know this is probably small to read on your computer screen, but look at today's handout materials. We are in chapter 3 of my book. Take a look at it. The order of proofs are in there, but they do follow a very specific order of proofs. And the reason I address this is because when you're defending a motion for med intemp, the first thing that happens after the motion's filed and effective defensive pleadings have been filed is the petitioner is then required to testify on their own behalf. that's an opportunity for most motions for med intempt to be resolved. So use this, the cadence of the court procedure to work with opposing counsel, maybe work with the court, maybe reach a compromise, or maybe not. You know, effective cross-examination of the petitioner may put an end to the motion needing to pend. So just be thoughtful about that. Remember as well that when they file a motion to take over medical care, that burden of proof is on them, the moving party, the petitioner. Another interesting issue that arises is there is no such thing as partial temporary disability in New Jersey. I know there is unpublished trial level orders in which judges have ordered partial temp, but just know there is nothing statutorily requiring you to pay partial temp. However, just my experience, most of my clients say, hey, Greg, we will voluntarily pay partial temp. We understand that the statute actually doesn't require it. I also point you out to an interesting issue where there are multiple potential respondents. Okay, think about successive employment cases. The judge can simply, where there is no issue as to whether or not the treatment is required, the judge may simply say, you, respondent number one, you're going to pay for all the care, and then we're going to figure out later who's going to reimburse you or apportion the liability. So the judge can do that, and that's really, it makes sense to me because it's going to expedite the resolution of the case. But be warned, this cannot be done where any one of the parties has raised a jurisdictional issue, like not my employee or I don't have coverage. And I was the first one who actually ever raised that and prevailed on that. If you want to see my case, it's called Calix versus A to Z Universal, which I made the argument that yes, normally a judge can apportion successive liability or may make a ruling in a motion for med intempt and then allow the carriers or employers to later fight out between themselves who's actually responsible. But just know that where one party has raised a jurisdictional defense, and in the case of Calix, our jurisdictional defense was not my employee. The appellate division agreed with me. They said, yeah, the judge, where the parties don't even know who the right employee is, employer is, the judge can't just say all of you might be the employer, so one of you is going to pay for the care, and then we're going to figure it out later. No, there needs to be an affirmative finding first as to who the employer is. So just be mindful, you are never waiving a jurisdictional argument when you're defending a motion for med intempt. Medical marijuana has come up in the past. A judge can order reimbursement of direct medical marijuana costs, cannot require us to pay directly for medical marijuana. New Jersey also has something called a motion for emergent medical care, which was created in 2007, in which the petitioner argues essentially that I need emergent care, and if I do not get it now, I'm going to suffer irreparable harm or damage. Like literally, I'm going to die. They need to explain what's going to happen to them. The respondent's time to respond is not 21 days as normal. It is only 5 days. And if we're going to get a defense IME, we only have 15 days to get that IME. These motions are meant to be listed emergently, but in my experience, and again, I've been practicing for 24 years, we just determined that today in this meeting, these are extremely rare, but should be treated with extremely high urgency. All right. That's the end of this presentation. I'm going to go over to the questions, and I hope there are some good questions. I know this is a long presentation. There's a lot of information in here, but I know we are all dealing with motion issues. So let's come over to the question panel. We do have a lot of attendees today, so I'm looking to see what questions we have. Let me go over to the questions and take a look. I've got my panel opened. Is this right? I'm hoping this thing is working. I don't see any questions to me. So either this is you guys know the answers to all these issues that arise or not. Or maybe the question box is not working, which I hope it is working. All right, let's talk about some other stuff, a little bit of housekeeping things here. And again, let me just click through. Please consider, if you think this is useful, join our newsletter. Listen to some of our podcasts, particularly my partner Christian's podcast, which is called Third Fridays and released the third Friday of each month. A few months ago, he did one about medical provider applications, was really useful. Last week or last month, he did one in which he interviewed some of our paraprofessionals, who started here as paraprofessionals, then went to law school, and then came back to work for Lois Law Firm as either law clerks or attorneys. It was just a great presentation about their journey. Let me come back over to questions and see if there are any popping in here. Okay, Matt says, Greg, you mentioned amendments changing the policy behind speedy adjudications. Can you explain how things were different before? Yeah, sure. So, Matt, there used to not be such a thing as an emergent motion for med in temp. But in 2005, 2006, 2007, there were a whole series of articles that were published in the local newspapers here, the Newark Star Ledger and the Bergen Record, about how petitioners in New Jersey workers' compensation cases were not getting a fair shake and were not getting motions for medical and temporary disability benefits heard quickly. This spurred some activity from the legislature, and of course they love to expand the statute to give the petitioner more advantage. And they created the emergent motion for med in temp. So as a legal device, as a device, as a basis for a motion, it's only about 18 or 19 years old, the emergent motion med in temp. But in my experience, very few of them are filed. And in fact, in the last 20 years, since they changed the statute to allow this emergent motion, I think I might have defended 3 of them in all of that time, and I'm defending thousands of cases. We are a huge practice. In that same period of time, I've probably defended 10,000 cases and only seen it a handful of times. And that's why I move so quickly through that section of the presentation on emergent motions. I want you to know that they are possible or potential, but I don't want to spend much time explaining it or going through it, because if you ever are confronted with one of those, my advice is get it to counsel as fast as you can and get your defenses in place. All right, Maria asked the question, Greg, can you provide a timeline or duration of expected discovery in these matters? Yeah, absolutely. So you do have timelines for when you can serve discovery on opposing parties, right? We talked about how in interrogatories, we have 15 days after we file our answer. The petitioner has 30 days. The timeline for responding to a interrogatory demand is 45 days. So we file an answer, we serve interrogatories, opposing party has 45 days to respond. If they don't respond, on day 46, we can file a motion to compel, right? So that is our timeline. And that's fairly typical, that we are not getting any response at all. We wait until the time elapses. My practice here is to communicate with opposing counsel at least once in writing to say, hi, I'm requesting this thing. You're obligated to provide it to me. Please provide it to me. And if you don't, I have to file a motion. Again, they generally ignore us because that's work and they don't want to do it. And then we have to file a motion to compel. So that's a very typical timeline. Some discovery responses have a shorter timeline. So a response to a demand for medical records is 30 days. But those are the 2 main timelines, 30 days for medical records, 45 days for interrogatories. But the general timeline or milestone is that all discovery needs to be completed 6 months after we file our answer or last payment of compensation. It actually says 180 days. So 180 days, the discovery period closes. And this can work 2 ways. If I serve discovery on opposing counsel and more than 180 days has elapsed, opposing counsel can come to me and say, nanny, nanny, poo-poo, I don't have to respond to you. You're outside of the discovery timeline. Okay? They can do that. In which case, I have to go file a motion before the judge and say, Judge, you should extend or enlarge the discovery period so that I can get this answer because I need this information. Something's developed in the case. I'm now entitled to this. You should require them to respond. Okay, so in general, your discovery period closes at 180 days, but there are exceptions to that, and those can be judge-created exceptions. So I hope that's helpful. Okay, another question. Do you find that the lack of administrative oversight, as in New York workers' compensation, makes New Jersey motion practice a favorable litigation strategy for practitioners with dual admissions? That's an interesting question. Well, comparing it to New York, unfortunately, motions in New Jersey are the only way you can force the opposing party to do anything. And often you have to do it to get traction in your cases. New Jersey workers' compensation courts, as compared to New York, are very different. Every time you go to court in New York, every time you walk out of court, you're walking out of there with an order, a judicial order, right? Every single time, a notice of decision, every time. In New Jersey, the practice is to go to court many, many times and rarely see an order signed by a judge. And so in order to get the judge to pay attention and to force the other side to do anything, motion practice is the key. So it is unfortunately both A, more litigious than New York, and B, less satisfying because it's less effective. The judge doesn't have to hear a motion. The judge, for any reason really, will punt, kick, or adjourn a motion and allow opposing counsel more time to respond, which we know in New York would never happen. In New York, my experience has been the judges, once they've directed the claimant to do something, if the claimant fails to do it, they're very happy to mark the case no further action or failure to prosecute. Whereas in New Jersey, that's a very rare thing for the judges to do. Your next question is, Greg, do you find the practice to be contentious in New Jersey? Is gamesmanship a common plaintiff's tactic? No, so I would say New Jersey is actually very polite and courteous in general. And that courteousness, though, or that amenability, unfortunately, is why everything gets adjourned, why petitioners' attorneys get the benefit of the doubt always, why things move so slowly, and why judges are so reticent to actually sign orders or to create obligations for the parties or to enforce the statutory or rule-based obligations. It's a very slow and frustrating litigation process in New Jersey compared to New York. New York moves at lightning pace compared to the pace that a typical New Jersey workers' comp case unfolds. And it's mainly because A, the plaintiff's attorney is, or the plaintiff is not really required to respond to discovery obligations. And we have to keep trying to force them to, or we need to keep forcing motions, and the judges are reticent or slow to grant motions. So the procedural progress of a case in New Jersey, the cadence, I would say, of litigation is maybe a third or 50% the speed of a New York case, maybe much slower. So just be prepared for, it's not particularly contentious, it's just very slow, and that's really because the party's not following the rules carefully. So I hope that's a complete answer for you and gives you some information. All right, it is 1 o'clock. This was scheduled for an hour and we got a lot of questions. This was a really great meeting. Thanks for coming, everybody. I hope to see you next month in our next webinar. Have a great rest of your week, everybody. Stay warm.